Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about pat-down searches. Cases that should have gone to the Supreme Court of Canada, but didn't. Devinder Singh Dhillon was stopped in British Columbia after driving by police and appearing startled when he drove in a high-crime area and police were present. The police ultimately took him out of his vehicle, conducted a pat-down search, and during the course of their search of Mr. Dhillon, who was detained for investigative purposes, they discovered a number of items that he was ultimately charged with and convicted of firearms offenses. Mr. Dhillon argued that the pat-down search that was done was unlawful, that police officers need to have reasonable grounds to believe there is an officer safety risk before a pat-down search is justified, whereas the Crown argued that all that was necessary was a reasonable suspicion that there was an officer safety risk. Ultimately, the court sided with the Crown, and Mr. Dhillon sought leave to appeal to the Supreme Court of Canada, who denied leave. But this case does raise very important issues. It has been a long time since the Supreme Court of Canada considered investigative detention and the powers of pat-down searches, all the way since the Mann decision. And in that case, the court found that it was only acceptable to conduct a search for immediate officer safety. But the idea of when an officer safety concern arises was not fully fleshed out in the decision. So there isn't significant Supreme Court of Canada jurisprudence about what the line is for when a pat-down search for officer safety can occur in the context of an investigative detention. And this is also a particularly interesting case because other than Mr. Dhillon appearing startled, there really was no justification for the stop, the detention, and then the ultimate pat-down. And so there was a concern about the extent to which the police were using broad powers that are given to them to protect their safety in a way that might potentially harass other individuals. And it doesn't matter that Mr. Dhillon was ultimately found with firearms. The real issue is whether the officer had the justification to conduct the search in the manner that he did. And clear statement from the law from the Supreme Court of Canada on this issue is an important part of understanding the development of criminal law in Canada and understanding for citizens the extent to which police can engage in these searches. It would be helpful for the Supreme Court of Canada to chime in on this because searches like this are happening not just in British Columbia but across Canada every single day, and individuals should be better equipped to know their rights, and Defence Counsel and Crown Counsel alike should be better equipped to know the extent of the law to prevent numerous cases in numerous provinces arising where arguments are being dealt with in relation to this issue. And unfortunately, it's going to take another case for the Supreme Court of Canada to fully consider the significance of this issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.